Let's take a look at government as part of the employment relationship. People differ in their view of what role government should play in the contemporary workplace. While some advocate for joint action between organizations and government to protect employee interests, others believe market driven change offers the best opportunities and should proceed without interference. All countries must address these issues, though they often take vastly different approaches. Governments typically focus on fair pay practice, safety nets for unemployed or disabled workers, and protections like minimum wage and overtime rules. In addition to being a party to all employment relationships, government units are also employers and purchasers. Consequently, government decisions also affect conditions in the labor market. The government not only plays a role in employing a large share of the U.S. workforce, but also shapes labor demand and supply through spending, taxation, legislation, and monetary policy. Laws designed to protect certain groups, such as schooling mandates and occupational licensing, can also limit their participation in the labor market. Immigration policy and how rigorously it's enforced is an increasingly important factor in the labor supply. The FLSA, or Fair Labor Standards Act, governs wage and hour standards for employees, covering minimum wage, overtime, and child labor standards. Employers are required to maintain detailed records of employees' hours worked and wages paid as part of ensuring compliance with FLSA regulation. Originally set at 25 cents per hour in 1938, the federal minimum wage has increased periodically through time. The percentage of U.S. workers earning at or below minimum wage has steadily declined since the late 1970s, largely due to inflation and changes in the labor market. While industries like technology and pharmaceuticals are largely unaffected by minimum wage laws, sectors such as retail and hospitality are significantly impacted due to their lower wage structure. Critics of raising the minimum wage argue that higher labor costs could lead employers to reduce hiring or cut back on workers' hours, potentially harming those the law isn't meant to help. The FLSA mandates that non exempt employees be paid at time and a half for any hours worked over 40 in a single work week. Wage and hour lawsuits often arise when employers fail to properly compensate employees for overtime or require work to be done off the clock. Additional laws, including OSHA rules and Portal to Portal Act, help clarify which job related activities must be paid, such as donating safety gear or traveling to a workspace. Employees who are on call may have not have the need to be compensated depending on how restricted they are during that time, especially if they must remain at their workplace. In response to administrative challenges, the 2000 Worker Economic Opportunity Act excluded stock options and certain bonuses from overtime calculation. Recent discussions around FLSA reform focus on offering more flexibility, including proposals that would allow employees to choose compensatory time off instead of receiving overtime pay. The FLSA remains a foundational law shaping how work is compensated and protected in the United States today. Although living wage provisions are not part of the FLSA, they are similar to minimum wage provisions. Maryland was the first state to enact a living wage law in 2009, with rates varying by location and exceeding the state minimum wage. Many cities and states, especially California, followed suit with ordinances targeting public contractors, universities, and specific sectors like airport or hotel workers. A study of Los Angeles ordinance found that it raised wages by 20% for covered workers, with minimal job loss, and added benefits like reduced turnover and better qualified hires. While living wage laws are often supported by unions and community groups, critics suggest that they may also aim to limit outsourcing and preserve government jobs. These laws continue to shape debates about fair pay, local control, and the role of government in setting wage standards. Employers must pay taxes and benefits for employees, but not for independent contractors. The difference creates a strong financial incentive to classify workers as contractors, especially since contractors aren't eligible for benefits like overtime or unemployment insurance. Law abiding employers face higher costs, while those who misclassify workers gain an unfair advantage unless they're caught. Workers also lose access to important protections and benefits when misclassified. Federal laws like IRS tax rules and ERISA govern worker classification, and states that have reported major losses in tax revenue due to misclassification. The IRS evaluates behavioral and financial control, as well as the performance of the relationship when determining employment status. High risk industries for misclassification include trucking, construction, home healthcare, and tech. In a major case, Microsoft was forced to reclassify contractors as employees and ultimately settled related lawsuits for $97 million. dollars. FedEx also faced multiple lawsuits and significant penalties when the IRS estimated $319 million dollars in taxes and fines for 1 year alone. The consequences of misclassification can be severe for both employees and for workers. Prevailing wage laws set pay for work done to produce goods and services contracted by the federal government. Prevailing wage laws require contractors on government funded projects to pay workers a wage that reflects the going rate in a given area, often set by unions. These laws were created in response to conditions on major projects like the Hoover Dam, where workers were easily replaced with low pay because of market conditions. While intended to protect workers and stabilize wages, prevailing wage laws can raise government construction costs by mandating pay above the market rate. For example, in Kentucky, public project plumbers were paid over 30% more than the Bureau of Labor Statistics market rate. Several federal laws contain prevailing wage provisions, including the Davis Bacon Act and the Service Contract Act, and some laws now apply these requirements to temporary foreign workers. Although rooted in Depression era policy, these laws have evolved alongside broader social movements, including the Civil Rights and Equal Pay Acts. Debate over their impact will continue. A major lawsuit involved 64,000 former tech employees. It alleged that Apple, Google, Intel, and Adobe agreed not to recruit each other's workers between 2005 and 2009, limiting employees' chances for advancement and higher pay. Steve Jobs was named as a key figure in the agreement, which reports that he directly influenced the firing of a Google recruiter who contacted and contracted an Apple employee. The companies offered a $324.5 million settlement, but a judge rejected it as too low compared to similar past cases. The parties returned to negotiations and eventually agreed to a revised settlement of $415 million, which was approved in 2015. This case highlights the impact of secret hiring practices. The law recognizes two types of discrimination: access discrimination and valuation discrimination. Charges of discrimination and reverse discrimination that most often make the news involve access discrimination, the denial of a particular job, promotion, or training opportunity to qualified women or minorities. A second legally recognized interpretation of discrimination is valuation discrimination, which looks at the pay women and minorities receive for jobs they perform. The Equal Pay Act prohibits paying women less than men for performing equal work under similar conditions, emphasizing the principle of equal pay for equal work. Some argue that pay discrimination extends beyond equal jobs, suggesting it's unfair to pay women in female dominated roles less than men in different male dominated roles when the work is of comparable value to the employer. While federal law does not require equal pay for equal work of comparable worth, some states have adopted this standard for their public sector employees. Significant pay equity adjustments have also been made in Canada. The Equal Pay Act of 1963 prohibits wage discrimination based on gender for employees performing equal work. Equal work is defined as jobs requiring equal skill, effort, and responsibility under similar working conditions, though courts have had to clarify what this means in practice. Employers can legally justify pay differences using four affirmative defenses: seniority, merit, production, or any other factor than sex. A landmark case, Schultz versus Wheaton Glass, clarified that jobs don't need to be identical, but must be substantially equal, and the actual job duties, not just job descriptions, are key in assessing equality. The Department of Labor provides criteria for comparing skill, effort, responsibility, and working conditions, while courts require these differences to be significant and time consuming to justify unequal pay. Time of day, such as working at night, does not count as a different working condition unless separated from base wage. Of the four defenses, a factor other than sex has led to the most litigation, encompassing business related reasons like shift differentials or temporary assignments. Employers must show that these practices are truly business related and not just patterns resulting in wage gaps. Many of these cases are settled before trial, so there's little definitive legal guidance. Questions remain about what truly counts as a legitimate business justification. The Civil Rights Act is a far reaching law that grew out of the civil rights movement of the 1950s and 1960s. Title VII of the Civil Rights Act prohibits employment discrimination based on sex, race, color, religion, or national origin. The law covers all aspects of employment, from hiring and compensation to promotions and training, and is enforced by the Equal Employment Opportunity Commission known as the EEOC. Other important anti discrimination laws include the Age Discrimination in Employment Act and the Americans with Disabilities Act, otherwise known as ADA, both of which add protections for older and disabled workers. Title VII claims often involve unequal pay or promotion practices, and several high profile settlements, like those with Merrill Lynch and Bank of America, show how costly these cases can be. Class action lawsuits are a common mechanism for these claims and can involve large numbers of unnamed plaintiffs, significantly increasing employer liability. A key legal hurdle in these suits is demonstrating commonality among class members, a requirement clarified by the 2011 Walmart versus Duke Supreme Court decision, which made class certification more difficult. In response, some employers are adopting arbitration agreements that require employees to waive their right to join class actions, though the legality of these waivers remains unsettled. Two main legal theories under Title VII are disparate treatment, intentional discrimination, and disparate impact, neutral practices with unequal outcomes. Courts have ruled that even if a policy applies to everyone equally, it may still be unlawful if it disproportionately harms a protected group and isn't job related. Applying these standards to pay remains complex, especially since legal pay differences can exist for dissimilar work. It's still not clear what constitutes pay discrimination in dissimilar jobs in the United States. Executive Order 112406 or EO 112406 prohibits discrimination based on race, color, religion, sex, and national origin. It's enforced by the Office of Federal Contract Compliance Programs, the OFCCP, which requires affirmative action plans including utilization analysis, goals and timetables, and action steps. Contractor reviews are initiated using the Federal Contractor Section System FCSS, prior review history, or random selection, and about 5% of contractors are reviewed annually. The process begins with a desk audit of workforce data, compensation, and personnel decisions to detect systematic discrimination. If concerns arise, the OFCCP conducts an on site review using statistical analysis like regression and interviews to gather evidence. Contractors must also file the EEO-1 report, and the OFCCP has proposed an equal pay report to include compensation data and hours worked. If systemic discrimination is found, the OFCCP issues a notice of violation or an NOV and may require a conciliation agreement with back pay and charges or changes in compensation. If no agreement is reached, the case may go to an administrative law judge, and penalties can include contract disbarment. In 2013, the OFCCP replaced its 2006 standards with Directive 307, allowing more flexibility to investigate complex pay discrimination. To avoid violations, employers must avoid discrimination and conduct self evaluations, ideally under legal counsel to preserve privilege. Several key points highlight legal cases and standards related to pay discrimination and comparable worth. In Gunther versus the County of Washington in 1981, the Supreme Court ruled that wage discrimination claims under Title VII can apply even to dissimilar jobs, unlike the Equal Pay Act. The court allowed that comparable worth claims could be considered under Title VII, but did not define clear standards for proving such discrimination. Courts have generally upheld the use of market rates to justify pay differences, even when jobs held predominantly by women pay less than male dominated roles requiring similar skill. In Spalding versus the University of Washington, the court rejected a statistical model claiming discrimination, emphasizing the complexity and judgment involved in interpreting job value and market data. Courts tend to trust market prices as inherently job related, though critics argue these markets can carry gender based historical bias. A second approach courts have considered is job evaluation systems, which assign point values to roles to establish internal comparability. In ASME versus the state of Washington, the state's own study showed that women were paid about 20% less for jobs of equal value. Still, the court ruled the state had no legal obligation to adjust pay. Despite legal setbacks, public employees and employers have increasingly considered pay equity studies and made adjustments through settlement or collective bargaining. The state of Washington found licensed practical practicing nurses, mostly women, performed work comparable to higher paid campus police officers, mostly men, highlighting disparities. Many state and local governments, where women comprise over half the workforce, have led efforts to implement comparable work standards. A typical comparable worth plan involves first, a gender neutral point system, second, identifying job groups by gender dominance, third, basing wages on male dominated job rates, and four, applying consistent pay to point ratios. While job evaluation plans offer structure, critics argue that they are not as objective as claimed and may clash with modern organizational flexibility. But the debate continues in policy and legal circles. Wage gaps between men and women are widest at the top and bottom ends of a wage scale. Both have narrowed since the 1990s due to gains in education and experience by women. In 2013, white non Hispanic men had a median income of $51,865 compared to $40,270 for white non Hispanic women. Racial and ethnic minorities earn less on average than white men, with Hispanic workers consistently at the bottom. Education helps explain some earnings differences. Asian women earn more than white women on average, while black women fare better than black men due to higher college completion rates. Key factors contributing to wage gaps include occupation type, work behavior, market conditions, union presence, firm and industry differences, and discrimination. Gender gaps are often linked to work life balance choices, part time work, and career interruptions for family care, while racial and ethnic gaps are more tied to differences in education and job experience. Despite more women entering management and professional roles, the glass ceiling remains a barrier at executive levels. Even women in higher skilled fields like science and engineering are more likely than men to leave their careers, suggesting advancement challenges persist. Wage gaps tend to grow with age, possibly due to family related workforce or exits in increasing barriers advancing over time. Employment in lower paying sectors like the nonprofit sector and smaller firms contribute to gender pay gaps, especially in fields like law. Firm level compensation strategies and the tendency for some firms to attract more women or minorities may influence earning gaps within the same industry. While the gender gap and wage gap is universal, in a number of countries, the size of the gap is smaller than the United States. Compliance with laws and regulations can be a constraint and an opportunity for a compensation manager. The regulatory environment certainly constrains the decisions that can be made. Once laws are passed and regulations published, employers must comply, but a proactive compensation manager can influence the nature of regulations and their interpretation. How can a compensation manager best undertake these efforts? First, join a professional association to stay informed on emerging issues and to act in concert to inform and influence public and legislative opinion. Second, constantly review compensation practices and their results. Such discussion cannot occur without the input of informed managers, and that's how the process works.